Hello and welcome to the Crone Law Firm's Facebook Live show. My name is Alan Crone. I'm the founding member of the Crone Law Firm. We're a law firm in Memphis, Tennessee that represents employees, executives, and entrepreneurs in disputes involving their ability to make money. And we're here today to talk some basic employment law on when can an employer fire a worker and when might that worker have recourse against the employer for being wrongfully terminated. I always start any conversation of this nature out by saying that there's a lot of activity that's not good business, it's not fair, it's not moral, it may not be ethical. But having said all of that, it may not be illegal either. There simply isn't against the law to be a bad manager, to be a bad boss, or to be unfair unless you're being unfair for a particular illegal reason. So let's get into some of the specific questions we've been asked and develop this idea a little bit more. First question is that we hear a lot: can an employer fire me for no reason at all? And ironically, the answer to that question is yes. If they're firing you for no reason, then they're not firing you for an illegal reason. And what we look for in cases to determine if someone has legal recourse for being fired is they must be fired for being in a protected category or for engaging in some sort of protected activity. Protected categories are things like your race, sex, national origin, religion, age, color, that sort of thing. Protected category, protected activity is, did I do something that gives me legal protection? Did I refuse to remain silent about or refuse to participate in illegal activity? Did I report my company, for example, to OSHA for safety violations? Or did I report a discriminatory act based on someone being in a protected category? Did I serve on a jury and I was out for jury duty, and so therefore they fired me because I didn't come to work because I was on jury duty? Did I file a workers' comp claim and so that's why they fired me? Or did I take extended family medical leave or other kinds of protected leave? Did I have a disability that I was retaliated against for asking for a reasonable accommodation? All of that is protected activity that if you're fired for that reason, the company may be liable to you for damages for wrongful termination. You see, what happened was you go back to common law, and I'm often asked, what is the employment at will doctrine? And the employment at will doctrine was a common law doctrine. Tennessee used to be a part of North Carolina. North Carolina used to be a part of Great Britain. And for most states in the Union, we get our common law from Great Britain. And I always say lords and serfs, because that's where the employment doctrine was born, was in the relationship between a lord and the peasants and the serfs that worked on his land. And that lord could employ people, not employ people, fire people. There was no restriction on what he could do with that relationship. And that has come down to us these days in the employment at will doctrine. So it means the employment at will doctrine is pretty simple. Anybody can be fired at any time for any reason. And these protected categories and conduct that I talked about before, those are all exceptions to the employment at will doctrine. And so if you feel like you've been treated unfairly and you want to determine whether or not you have a case against your employer, you have to look to see, is there a exception to the employment at will doctrine at work here? And so that's where you go back to look and say, all right, what's the motive behind the reason I was fired? I always like to ask people, what was the real reason you were fired? They say they fired you because of your performance, or they say they fired you because you were late or you didn't come to work. But you may say, no, that's not the real reason, because I'm African American and there were white employees who did the same thing I did, reported to the same supervisor I reported to, and they weren't fired. But I and all the other African Americans, when we do that, we got fired. Or maybe it's because of your sex. All the women in the office if they engaged in certain conduct, then they were fired, but the men weren't fired. Or my supervisor made it clear, or the decision maker made it very clear that that he or she had a prejudice or a bias against certain kinds of folks and that sort of thing. So you've always got to tie it back. There always has to be a causal connection between your inclusion in the protected class and the adverse employment action, which is usually, when people come to see me, is usually termination. But reassignments, promotions, suspensions, write-ups, those are also adverse employment actions and can give rise to liability if there's a discriminatory intent. So the illegal reasons to fire somebody would be their inclusion in those illegal categories. So what happens? Can I sue my employer if I'm illegally fired? What do I have to do? Well, anytime that you feel like you're the victim of discrimination, you should report that, or illegal harassment. You should report that to human resources or your boss or the owner of the company, depending upon the size of the company. But let's say you've been fired, so there's really nobody to report it to. One thing you can do is go to the EEOC, the Equal Employment Opportunity Commission, and file a complaint there. And you need to make sure that when you're filing there that you can factually tie the termination to the discrimination. So you want to be prepared to talk about the real reason you were fired. You want to tell the investigator, I was fired because of my sex, or because I reported illegal activity, or because I complained about illegal harassment, or because I went on jury duty, or I filed a workers' comp claim, or whatever the issue is. The EEOC is charged with investigating all cases of illegal discrimination that occurs in the United States, and they have district offices that do this. So they have a lot of work to do, and they tend to focus on particular cases, and what they focus on tends to change over time. And so sometimes the EEOC, for whatever reason, even though you may have a meritorious claim, may not take your case. In fact, I'll tell you, I've done this for over 25, almost 30 years, and I can count on one hand the number of cases I've been involved in where the EEOC has taken a case and prosecuted it for an individual or a group of individuals. The vast majority of cases, the individual is given a right to sue letter, and then that allows that person then to file that complaint in federal court within 90 days of receiving the right to sue letter to pursue the case in court. So if you file with the EEOC, you really ought to consider going to see a private attorney either before or shortly after you file the EEOC complaint, so that that attorney can help you, A, work with the EEOC to get the best result possible there, but also to start to prepare for the possibility that you may have to file your own lawsuit. And that can be very time consuming, can be very expensive. But if the action has meant that you've been out of work for a long period of time, then you may, it's definitely worth pursuing if you have a valid claim. And these claims are very dependent on the factual circumstances of your situation. And so it's very, very difficult to compare one case with another. You really have to look at each case standing alone. And so that's why it's important to go see an attorney as soon as you can, because the chances are that the EEOC won't take your case. And even if they do take your case, that becomes the EEOC's case at that point. And they're the ones who call the shots. Now, they've got a great track record for making sure that people are compensated fairly. But it's always good to have your own counsel to help move the process along. So the next question is, a pretty logical question is, well, if I file my employer, what can I get? What's my case worth? And these cases, particularly in places like Memphis, are not nearly as valuable as people think they are, oftentimes. And the real measure of damage is how long are you out of work. The main element of damage is what we call back pay and front pay. Back pay is the amount of money you would have made if you hadn't been fired or suffered the adverse employment action. Maybe you were demoted or maybe you were suspended, absent the illegal activity. So up to the point of the settlement or up to the point of the trial. So let's say you're fired on January 1st, you file a complaint, and the trial happens the following January 1st. Well, then your back pay is 1 year's worth of damage, 1 year's worth of salary and benefits. Your front pay is the difference between what you would have made and what you're actually going to make going forward. That's what we lawyers call an equitable remedy, and so it's difficult to determine how far into the future you can get front pay. That money has to be adjusted to present value. So what you do is you hire an expert to help you calculate what that pay would be. And I've seen front pay awards for 1 year or 2 years, and I've seen them for 5 or 10 years. Just really depends on your particular situation. You have a duty to mitigate your damage. And what that means is that from the moment you're fired, you need to make a reasonable effort to get reemployed in the same or similar type employment. And so it's important to document that, all the activity and all the effort you make to hunt for a new job almost from the very, very beginning. And that's one of the things that we counsel our clients on and help them do, is to document every website they visit, every networking phone call they make, every conversation they have about looking for a new job, so that the employer, if they end up suing them, doesn't Monday morning quarterback them on their inability to find another job. And sometimes it's real easy to find substitute employment, and there's some cases where it's nearly impossible. I've had clients where their former employer was literally the only employer within 200 miles of their house where they could perform a same or similar job. But that still doesn't relieve you from the obligation to look and to try to find substitute employment, even if it's not exactly the same. Juries tend to look more favorably on litigants who have worked in the meantime, even if it's not at the same job, than somebody who's just sitting at home. But again, every case is different, and it's all a matter of how that is presented. Another element of damage is what we call compensatory damage. In an automobile accident scenario, you might call that pain and suffering. That's much more difficult to recover in these employment cases unless you have egregious conduct on behalf of the defendant. Because a lot of people who sit on juries think, well, getting fired is kind of part of life, and that's just part of what you have to suffer through if you're going to be in the workforce. And so you don't get nearly as much compensation for pain and suffering for just what we call garden variety anxiety having been fired than if you've had a medical or a mental ramification from it. And that could be anything from stress to high blood pressure to hypertension, that lack of sleep that result in some physical manifestation with some medical records or therapy bills. Then when you have that situation, you have the ability to get more than just a few $1,000s. But under federal law, there are caps on that kind of damage, and the caps for smaller companies are $200,000, and the caps for larger companies are $300,000. So that's the most you can get. You can't, under federal law, you can't get punitive damages, although state law is a little more generous in Tennessee and other states. But these are not cases where you see huge verdicts absent some dire circumstances on behalf of the plaintiffs and some really obnoxious conduct on the parts of the defendants. So usually what you're looking for in cases like this is you're usually looking for enough money to get between where you are and where your next job is, and then a little bit of something for the effort, and have your attorney's fees recovered. That's the third element of damage, is recovery of your attorney's fees. And so you can get all or part of your attorney's fees as part of the settlement or verdict if the case goes fully to trial. That's kind of hitting the high spots, if you will, of the kinds of cases that can be brought and the kinds of damages that you can recover. It's definitely a reasonable thing to do, to want to be compensated if you are illegally and unjustly terminated. And if you have been and you think that you might have a case, I would encourage you to go to the EEOC, find a private attorney such as the Crone Law Firm to help you evaluate whether or not, in fact, you have a case. I can tell you that we get literally hundreds of calls a month for these kinds of things, and we take only a very small percentage of those cases as clients, because unfortunately many people who are treated very, very poorly and very badly by their employers, we sometimes have to deliver the bad news more often than not, that unfortunately, even though you were treated so shamefully, what they did is not illegal. But don't assume that that's your circumstance. Check it out, cross that off your list, and if you have a claim, pursue it. And if you don't, then I always say the best revenge is living well. And I appreciate everybody watching, and we'll look forward to talking with you next time on our Facebook Live show. Thank you.